Welcome to In the Name of the Law, with your host, Lisa Speaker from Speaker Law Firm. Joining her today is Stephen Sinas from Sinas Dramis Law Firm, Brandy Thompson from the Kronzek firm, and Mary Chartier from Chartier Nyamfukudza PLC. Now, let's discuss some remarkable stories and real cases.
Welcome to In the Name of the Law, a legal talk show about real legal problems.
In the name of criminal defense.
Today, Mary Chartier and Takura Nyamfukudza of Chartier Nyamfukudza are here to talk about criminal justice reform. Now, we have a new president, and we want to look at what's going to happen in our country at the national level for criminal justice reform. Mary and Takura, what changes do you see coming?
Well, a lot of changes, Lisa. President Biden and Vice President Harris have spoken quite a bit about criminal justice reform. We have to recognize that, at least for us, it probably won't come fast enough or enough changes just because there's so much on their plate. They've got COVID, they've got the economic disaster from COVID, they've got the insurrection at the Capitol to deal with, we've got climate change, all kinds of really important issues for them. So, I don't even know how they're sleeping. But one of the platforms that they ran on and one of the issues that they are committed to is criminal justice reform. One of the things we've got to remember is criminal justice reform at the national level doesn't have that direct impact on the states. So, for example, most people, their encounter is with a county prosecutor. So if there's a change to the federal system, it's not necessarily going to change state laws, but it does set policy changes and send the country in a positive direction.
So what should we expect in the next maybe 100 days or year?
Well, one of the things that President Biden has said is mandatory minimums. And I know, Takura, that's an issue that is near and dear to our heart, right? That impacts so many of our federal clients.
Okay, so tell us what that means for your clients.
So in cases, irrespective of whether there was any violence involved, if you have a certain amount of drugs, you know you are going, and again, the judge does not have any discretion whatsoever. But, and we're not talking about kilograms and pounds of drugs, right? Relatively speaking, I think some gram amounts. Now, while the amounts, the threshold amounts may have been lowered, still people are spending decades away from their family for user amounts of drugs.
So one of the things in the federal system, as Takura said, Lisa, is you look at the drug weight. That's the driving force on time. There are all these other things that get factored into it. But certain drug weights come with a 10 or 15-year mandatory minimum in prison. It's a long time for someone, and a lot of times, who's never been in trouble before. And then in a conspiracy case, it's not just my drug weight, it is the drug weight that Takura had. So I might say, well, yeah, Takura, I'll introduce you to my cousin Lisa, right? I know she, dabbles a little bit in cocaine distribution, which I know you don't, Lisa, right? And we're not cousins. But then if they wind up cooking up a deal for X amount, now that drug weight is on me, even though, I wasn't directly involved in it. It's extremely onerous. And there's actually a lot of research from the federal government itself saying that these really lengthy sentences for drug possession and drug distribution, they're not effective. They're not effective at all.
Even at the state level, I think there've been studies where MDOC says, look, like 3.5 seems to be the magic number, where after people spend more time than that, there's no direct link between the rate of recidivism or, so 3.5 years. And again, of course, there are exceptions, but yeah, these 10, 15, 20 years sentences, there's no reason for them.
One of the things, now this is not on President Biden's platform, but if I ever spoke to him, I would talk to him about it, is the disparity between white collar financial crimes and then drug distribution crimes. So if you look at the cost of drugs and then you look at the sentence that someone gets, right, for drugs that cost, let's say, $1,000, and then you look at what the sentence would be for someone who was involved in a financial crime where it was $1,000, there's a vast difference. And I think we know why that is, right? I think we can look at the systemic racism that's embedded in our system and look at why that sentence is so onerous. And when you think about it, no one agrees to participate in a financial crime. So for example, I'm not saying, hey, I'd like you to steal my money. But in drug crimes, you do have people who, are agreeing to be drug users. I'm not saying that makes it right, but I'm saying we are looking at consensual versus non-consensual activity and punishing non-consensual activity vastly differently than we do what would be considered consensual activity.
Well, you mentioned racial injustice. I think that maybe leads us to the issue of the death penalty. Do we have any changes coming maybe with the death penalty legislation?
So President Biden is opposed to the death penalty for all the reasons that many people can think, right? There's racism embedded in it, but there's also huge flaws. Since 1973, 160 people who have been sentenced to death have been exonerated. So a jury actually considered their case, heard all the evidence from the government, heard the defense put their case on, and then said this person is guilty, and then the sentence was death. And then appellate courts have looked at all of these cases and said, nope, trial was right, we've got the right person. Only later, through groups like the Innocence Project and other attorneys, most of whom are volunteering their time, have the individuals been exonerated. And that should be shocking and frightening to every single person who thinks about this issue. We would have killed 160 innocent people. And we know in this country we have killed innocent people under the death penalty.
Wow. Any other changes in the criminal justice system?
Well, I think most U.S. attorneys have a policy when it comes to charging where if there are multiple counts on an indictment, where they need to get the stiffest possible sentence, right? So, and also you are penalized. I think you're penalized for going to trial because you don't get those acceptance of responsibility points. In the federal system, there's a grid. The amount of time you do, you get points. This is where we plug you in. The horizontal and vertical axis intersect, and that's where we plug you in. But yeah, the most onerous sentence they can get, and you get points added for going to trial, for exercising your constitutional rights.
The prior policy from the administration was you charge as much as you can in terms of what the counts are, and then you plead them to as high a count as you possibly can, which really strips prosecutors of a significant amount of discretion. So I think what Kerr just spoke about is fantastic. We hope in terms of allowing prosecutors to look at an individual and really consider what they think the appropriate charge is and what they think the appropriate sentence should be.
I heard there might be an issue with methamphetamine. Can you explain that?
So right now, there's a big disparity between meth mixtures and actual meth. And so it's a 10-to-1 disparity. So essentially, someone serves 10 times longer in prison for a pure meth than they do meth mixture. It's not supported by any research whatsoever. And in fact, most of the meth on the street is pure meth, yet you have people serving decades in prison for it. Cash bail, there's been a big discussion about eliminating that. I know Takura was very involved in that at the state level, and that's really significant.
Yes.
I want to go back to the bias, the inherent bias built into the criminal justice system. If you could comment on that.
So one of the things that President Biden has said is they're really going to study places where bias comes in, from arrests to charging to sentencing. And that's a very refreshing philosophy to have. And when we spoke earlier about the death penalty, the case that Tukur and I spoke about in an earlier show that we worked on, people should recognize, Mr. Hamilton, we exonerated him. He'd spent 26 years in prison for a murder he did not commit. every single step of the way, every court put their stamp of approval on that conviction. If Michigan had been a death penalty state, Mr. Hamilton would have been dead long before Tukur and I ever met him. So for people to think that the system is infallible is just not true. I mean, we know there are so many flaws in it. We know there are so many biases. And so it is refreshing to, we hope, see some true reform to address that.
Would you think there's going to be a commission studying what to do, or how does it work at this level?
That's the plan. That's the plan, is that there's a commission. And honestly, we should have one in Michigan, right? The number of exonerations that have occurred in Michigan, we should have a commission studying these exonerations, what led to these wrongful convictions, and then how can we improve our system to stop them from ever happening again.
Well, thank you very much for your insights today. We really appreciate it.
Thanks. And if anyone is interested in learning more about this issue and more, please check out our podcast, Constitutional Defenders. It's on every platform where podcasts are hosted.
In the Name of Criminal Defense is brought to you by Chartier Nyamfukudza PLC. In the Name of Family Law.
Welcome back to In the Name of the Law. Today we have Josh Pease, who is an attorney at the Kronzek law firm, and we're going to talk about termination of parental rights. So to get us started, Josh, tell us what does it mean to have your parental rights terminated?
Termination of parental rights essentially means that you would no longer be the parent to your children. You wouldn't be able to make any decisions for your kids anymore. You would not be entitled to visit your kids anymore. And if your children were to pass before you, you couldn't inherit from your kids. Effectively, there's no more legal relationship between you and your children in any regard.
I think there's one important exception to that, though, Josh, isn't there, with respect to child support? Wasn't there a case that required?
Yes. So in Rebecca, it regards parental obligations. So if parental rights are terminated, the parents still are required to satisfy obligations towards the children. So just because a parent's rights are terminated doesn't mean they're off the hook for child support.
Right. And I think part of that was, for parents who might be just saying, hey, I'm willing to give up my rights to walk away, thinking that they could avoid a support obligation.
Right. So if a parent's goal is to avoid child support by releasing their parental rights, courts will not allow that. The child support order will continue.
So what would be reasons to terminate a parent's rights?
There are a lot of reasons the state of Michigan might try to terminate a parent's rights. Some of the major ones are if the parent has been accused of sexual abuse of the child or a sibling of the child, severe physical abuse, something more serious than slapping the child, but something that may lead to broken bones will often lead to a request to terminate parental rights. If the parent has a history of having their parental rights terminated for any various number of reasons and hasn't fixed the issues which led to those previous terminations, that can be a basis for terminating parental rights. If the parent is participating in an ongoing case with Children's Protective Services and there's a service plan to try to resolve whatever issues have been identified, and the parent doesn't participate in that service plan, that can be a basis for a court entering an order. In different circumstances, if a guardian wants to have the parental rights terminated so they can adopt a child, that can be a basis if the parent hasn't been sufficiently visiting with and providing financial support for the child.
So in my practice, we see a lot of cases that sound less severe than what you're talking about, where a parent's rights are terminated maybe because they have a drug abuse problem that they're struggling with. And so it's more neglect of the children, or I think I see a lot of where a child is born with the parent is on drugs when the child is born, and so the child is taken right from the hospital. Can we talk about that for a minute, those types of cases?
Of course, and those are probably the most common types of cases that end up in court involving Children's Protective Services, where parents have substance abuse issues, which will lead to the state of Michigan saying, we don't think it's safe for your children to be in your care. Most of the time, those parents are given an opportunity to get clean and to resolve those issues. If they get clean, generally they'll get their kids back into their care. But for the parents who continue to struggle with their substance abuse and simply can't get clean in a reasonable amount of time, usually within a year or so, in most cases, the courts will start moving toward termination of parental rights.
Let's talk about when the termination actually happens. And I think, we talked about one scenario with substance abuse, but I know there's other examples of termination happening sooner in the process.
Yep. So when there's a case service plan, if the court gives a parent an opportunity to work toward reunification, generally there's some time given, and there's a general benchmark of around a year. If a parent hasn't done anything within a year, then they might move toward termination. On the other hand, there are certain cases where the state of Michigan will request termination of parental rights right away. And those are generally the cases involving sexual abuse and severe physical abuse and some other aggravating circumstances. If those aggravating circumstances don't exist, the parents should be given an opportunity.
And just to your point, Josh, if there isn't an aggravating circumstance, my understanding is that the Department of Health and Human Services is required to offer services to the parent because the goal is to reunify the child and the parent. So they should have what you call this case service plan, where they're given a chance to, fix the problems in their life. And just for a brief moment, can you tell us about what some of those services might be for a parent who's facing this situation?
Sure. I'll focus a little bit on the substance abuse because, like I said, that's one we see most often. We tend to see an offer of a psychological evaluation to determine what the parent's needs are. They're often given counseling, substance abuse services, drug screens. Parenting times will tend to start supervised and move toward unsupervised. There are parenting classes, anger management classes. There's a whole litany of services that can be offered, but it really depends on what the facts of the case are.
So the case service plan is tailored to that parent and child relationship?
It's supposed to be, yes.
Okay. So what about when a parent's incarcerated? Does that change the analysis at all?
It can. If a parent is going to be incarcerated for 2 years or more, that could be a basis for termination of parental rights. So if a parent's going to prison for some sort of felony, drug crime, violent crime, whatever it may be, and it's going to be for at least 2 years, they might move toward termination of parental rights early on. If a parent's sitting in jail for a few months on something minor, the agency will still have an obligation to provide some services and try to work toward reunification.
So once parents' rights have been terminated by the trial court, is there any way for them to get their rights back?
So the first step is the appeals process. There is a right to appeal the termination of parental rights. You don't even have to ask permission. You can just file for an appeal. That has to be done in a timely manner, though. If someone chooses to wait and they don't file an appeal within 63 days, they can never file an appeal. And unfortunately, the appeals process is the only way a parent can get their parental rights back.
I guess then the next question, so there are some parents who have been successful on appeal and they're able to be reunified with their children. But what happens if, the appeal, runs its course, they're not able to be reunified? What happens next with the children?
There are a few different options that can have. The court still has an obligation to reach a permanency goal with the children. The main one we see after termination of parental rights is adoption. And they'll consider family, foster placements, anyone else interested in adopting. For some children, particularly older children, they may pursue a guardianship instead of adoption. There are also circumstances with older children, particularly those 16 or older, where they'll pursue independent living, where they're looking to have the child develop the skills where they can support themselves, and there's no set, adoptive parent or guardian or anyone else. It's just the child on their own.
Well, all in all, this sounds like a very serious topic. And if a parent, is facing a petition for abuse and neglect from CPS, sounds like they should take it pretty seriously, because the consequences are severe and irreparable, right?
This is the most severe penalty a civil court can give anyone. So I think it's as about significant as any legal proceeding can get.
Well, Josh, thank you for sharing this overview with us. I know we could probably spend hours talking about this together, so that we'll maybe have a deeper dive on a future occasion, but we really appreciate helping us understand just the basics of a termination of parental rights case.
Of course. Thanks for having me today, Lisa.
In the Name of CPS Defense and Family Law is brought to you by the Kronzek firm. Go to WLAJ.com for more information on today's topics and to view other In the Name of the Law episodes. In the Name of Personal Injury Law.
We all know we buy something called auto no-fault insurance, and we may have also heard about how the no-fault insurance laws have been changed. There's so much about the no-fault insurance that it seems complicated. That's why we're happy to have personal injury attorney Steve Sinas back with us today to explain some of the specific aspects of our no-fault insurance system that we may have heard about but really don't understand. Steve, thanks for being with us today.
Great to be here. Thanks for having me.
So the aspects of the no-fault insurance system that we want to talk about today are the Michigan Catastrophic Claims Association and the Assigned Claims Plan. Steve, what about these complicated sounding entities and how they affect people injured in car crashes?
Well, the first thing to understand is that they're completely different entities. Okay, so we have the Michigan Catastrophic Claims Association. We're going to talk about what that does, and we have the Assigned Claims Plan. So people hear about the two, and in my experience, they often confuse them, but they're completely separate. So I think we should talk about them separately.
Well, let's start with the Michigan Catastrophic Claims Association.
All right, so some of us may have heard about this entity and we don't know what it means or what it does. So the Michigan Catastrophic Claims Association is a reinsurance fund. So people, when they hear about the MCCA, that's the acronym that they use for it, they should think reinsurance. And in terms of what it's reinsuring people's lifetime medical care that they're entitled to under our Michigan No-Fault Insurance Act. So the way this really works, and the way it's worked historically with our no-fault system, is that someone is injured. They typically turn to their own insurance company for their medical expenses that they need covered through Michigan no-fault insurance, and their insurance company pays their claim. But after a certain amount of money, and right now it's about $550,000, after their insurance company pays that amount of money, any amounts they pay over and above that get reimbursed and ultimately paid by the Michigan Catastrophic Claims Association. So that's where it's a reinsurance fund. It goes in and pays back the insurer for any amounts over and above that. I should note, though, that not everyone under the 2019 reforms will have that lifetime coverage I was talking about. But prior to the reforms, everyone did. Now people have to choose their lifetime coverage in order to keep their right to that type of coverage going forward.
Exactly. So how does the Michigan Catastrophic Claims Association get its money to pay over the $550,000 that the insurance companies are paying?
Yeah. So with regard to how that works, if everyone looks at their insurance declaration page, which is that one sheet you get from your insurance company that explains your premiums, you'll see a line item for the MCCA. And so they charge us all an assessment fee. They've been charging us that for years. They now have over $20 billion in their reinsurance fund, given the money they've taken in from all of us and also invested it, things of that nature. But they have this huge amount of money that ultimately has come from us, Michigan motorists.
Well, that's helpful. Thank you, Steve. And now explain, can you, the assigned claims plan?
Okay, so with regard to the assigned claims plan, what people need to think about is a situation where an individual is injured in an auto accident. They're not disqualified from no-fault benefits, which you can be in certain situations. But let's say they're not. So they're injured, you're entitled to benefits, but you don't have your own insurance policy, and there isn't an insurance policy in your household. In that situation, especially under the 2019 reforms, most of those people are going to end up claiming benefits through the assigned claims plan. And so let's talk about what that plan is all about. It's this plan that exists where people file a claim. They technically file it with this entity known as the Michigan Auto Insurance Placement Facility. And then that facility takes in the claim, and then they assign it to an insurance company that actually participates in the assigned claims plan. And with regard to the insurance companies that participate in that plan right now, there are 6 of them. It includes Allstate, AAA, Citizens, Nationwide, Farm Bureau, and Farmers. And so this facility takes in the claim and they randomly assign it to one of those entities. And then that insurance company has to take over the claim and pay it as if it was their own insurance claim, even though they had nothing to do with the person claiming the benefits. So it's a little bit counterintuitive, but that's how it works. And that's how the system deals with those who don't have insurance. There are some important points to make about the 2019 reforms. Prior to the reforms, anybody who had to turn to the plan was able to receive lifetime medical expense coverage through the plan. Now, everyone who turns to the plan is not entitled to lifetime coverage, and in almost all circumstances are going to be capped at $250,000 of medical expenses. So if you're one of these people who are injured in a crash, say you were a pedestrian, maybe a bicyclist, maybe you chose not to have car insurance because you just didn't need it. So you're in that category of people who don't have insurance. You're going to end up most likely claiming benefits through this plan. You're going to have to deal with their procedures and their claim forms and get the claim properly established. And then once you do, your medical expense coverage is going to be capped at $250,000. If you have medical expenses over and above that amount and you're not at fault, you can maybe pursue the at-fault driver for your uncovered medical expenses, which is also a new feature of our reform no-fault system.
So it sounds like the people that might be at greatest risk are people who don't have insurance because maybe they don't even have a car, like you said, like a bicyclist who's injured by a vehicle. Wow. And
there are also children out there who are in households that don't have insurance, and under the original law, they had lifetime coverage. Now they turn to the ACP and they're capped at $250,000 of medical expenses, which can be a real heartbreaking piece of information to tell people now under these new laws.
It's really not very much money if you have a serious injury. Medical care is very expensive, right, Steve?
Exactly. It goes by much quicker than you think.
So where does the assigned claims plan get the money from to pay for the $250,000?
The Michigan Catastrophic Claims Association, it ultimately comes from the people of Michigan, but it's not as explicit. If you look on your declaration page, you're not going to see a fee that is associated with the ACP. It's baked into the cake, so to speak. The amount you pay your insurance company includes an amount that goes to the ACP, and that actually funds the plan so that it can pay these claims as I've just described.
And all the insurance companies who provide auto insurance in Michigan fund the plan, not just the 6 who are participating as the actual insurers, right?
That's a great point, and that is correct. And ultimately, I'll just leave you with this. Michigan no-fault insurance is not intuitive. There are these entities that exist. You have to understand how they work, and then you also have to understand how they affect your rights as an injured person.
Steve, thank you so much for this really informative session today, and hopefully we'll have more information going forward. Thank you.
Thank you.
In the Name of Personal Injury Law is brought to you by the Sinas Dramis Law Firm.
Thank you for watching In the Name of the Law. We'll see you next week.
Thank you for joining us today for In the Name of the Law. Please go to WLAJ.com for more information on today's topics, and please join us next week for another informative show.